The Honorable Justices of the Supreme Court. Hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh and give their attention to the court now sitting.
Please be seated. Good morning and welcome to the Kansas Supreme Court. We welcome not only those who are in the courtroom today, but also those who might be watching us through our live stream. Today ends our docket this week. We have ultimately 5 cases that we will be hearing this morning. Before we hear those, I want to just briefly explain a couple of things about how we function. We come here today with a variety of cases that are arriving to us in 3 different ways. The first case comes to us through appeals from an administrative proceeding. The second is a proceeding that started in a Kansas courtroom, then went to the Court of Appeals, and then from the Court of Appeals to us. So, but in all of those cases, they share the fact that we are presented with materials from those other proceedings. So we have a record of those that we review, as well as the written arguments of the attorneys that the attorneys have presented to us on the legal issues that are being raised here. So we have taken notes about those, we have studied that, and we have done our own research before we come in today. And so during this process, we will be not only letting the attorneys make arguments to us, but also most likely asking questions of them on points that we either want clarified or to hear their response or to build on their arguments as they've made them to us. So we have before us computers and stacks of notes and other things, and we will at times be looking at those documents, but please know that when we do that, it is to augment and the argument, to refresh us. So we, as we're looking at things, it's not because we are distracted by something else on our computer. Rather, it's part of our being engaged in the arguments that are occurring today. And with that, I will ask Mr. Doug Shima, the clerk of the Kansas Appellate Court, to please call this morning's 9 o'clock docket.
Thank you.
First case on the 9 a.m. docket for Friday, May 10th, 2024 is appeal number 126642, Free State Electric Cooperative Incorporated et al. Appalese versus the Kansas Department of Revenue, Division of Property Appellant, Shawnee County, briefs both sides.
May it please the court, Ted Smith for the appellant, Property Valuation Division for the Kansas Department of Revenue. I'd like to reserve 3 minutes in rebuttal time, present and ready for argument.
3 minutes is granted. Thank you.
May it please the court, Greg Musil here with my partner Chris Maddox on behalf of Free State Electric Cooperative, Inc. and the other 7 appellees, and we are present and ready for argument, Your Honor.
Second case is appeal number 125534, in the interest of A.S., a minor child, Leavenworth County, briefs both sides.
May it please the court, Chadler Colgan, attorney for appellant Father H.S. May I reserve 3 minutes for argument?
3 minutes is granted.
Present and ready. Thank you.
May it please the court, Ashley Hutton, appellee, state of Kansas, present and ready.
Your Honor, that concludes our 9 a.m. docket.
This time then, if the attorneys in 126642, Free State Electric Cooperative versus Kansas Department of Revenue, Division of Property, would like to move forward.
May it please the court, Ted Smith for the appellant, Property Valuation Division, be referenced as PVD through arguments for the Kansas Department of Revenue. Thank you for this opportunity to present. And again, I'd like to reserve 3 minutes of rebuttal time. Primarily, this case revolves around evaluation of a series of nonprofit rural electric cooperatives and the valuation approaches and methodologies prescribed by the Property Valuation Division through its director, David Harper, as it extends down to the actual performance of the valuation by the PVD and basically determination of unit value for each one of these 8 nonprofit rural electives. Now, this is sort of different than your normal valuation case because when we deal with utilities, it is not the county assessor or appraiser who's coming in and supporting their validation. PVD is basically setting the methodology, setting prescriptions under USPAP and its own best judgment for the best valuation policy in the state. That's being communicated down to PVD staff who then perform the valuation. So they're doing both.
I ask you about that.
Yes, sir.
Has to do with the burden of proof and issue of what I would call jurisdiction, just exactly what did BOTA decide? Here's my question. In a valuation case, statute provides that county appraiser or the appraiser has the initial burden to come forward with the with why it did what it did, and to set that up. And that's the way it normally happens at BOTA, and then it would go up. Well, we've got this de novo review at the district court, right? Seems like there's a real lack of alignment between statutory schemes that we've been used to, this, de novo animal that we've got. My question is, once it gets to the district court and it's de novo, shouldn't the division have had that same initial burden come forward with its valuation methodology and then let the taxpayer respond to it, as opposed to the way the APA, the Administrative Procedure Act, comes right out of the chute and says, the petitioner has the burden of proof. You see what I'm saying?
I do,
And
Justice Byron.
so shouldn't that have been the way it worked at the district court? That's one question. Second question is looking at BOTA. The fact that BOTA didn't go through the analytical process that it always goes through evaluation case tell us that BOTA didn't think, at least, that it had that valuation question for it.
Let's
That all
begin.
makes sense?
I think.
Okay.
And I'll try to answer your question, starting with the first one. This is something the parties struggled with during the course through BOTA and through the district court review. And Department of Revenue basically maintains that the burden rested on the taxpayer in this case with regard to providing evidence in support of the fair market value evaluation.
At what level?
Both at the BOTA level and also at the district court review de novo. That being said, in the last 5 or 6 years, there's been a lot of movement legislatively to shift that burden in many property tax cases, residential, some commercial. The legislature has not addressed this issue of utility valuations. So we've maintained that the burden still continues to reside on the taxpayer in these circumstances.
Your position would be that at BOTA, you did not have that same initial burden that county appraisers and appraisers have typically in a BOTA case, in oil and gas and other kinds of valuation cases.
Well, I would say this case is a little bit different in the sense that part of our argument is that there's 2 different legal defenses or arguments being made. We have issues of uniform and equal, and we have issues of fair market value and valuation. And I believe those issues are separate. Now, I understand that fair market value oftentimes is a component of establishing uniform and equal, but there are also circumstances where they're at odds. This court and the United States Supreme Court have been clear that when there is any kind of tension between those two concepts, that uniform and equal is basically controlling. Now, in this case, PVD provided a use PAT valuation that was provided to the taxpayer. It concerned an evaluation of comparable sales, cost approach, income approach. It basically factored to put a lot of emphasis on the income approach. And that was submitted to the taxpayer and also was an issue that was presented to BODA. That is the only use PAT valuation that was before BODA on this issue. Now, the taxpayer basically in its appeal to the Board of Tax Appeals primarily stated this is an issue of uniform and equal. Department of Revenue PVD provided its use PAT valuation to basically support its estimate of value. The taxpayers presented argument from an independent individual, expert witness, who basically had previously been a tax rep for these recs. And as a tax rep for these recs, he had basically formed this opinion regarding how to treat net operating income. In his report to BODA and in his report to the district court, he was very clear to say, I'm offering this opinion regarding issues of uniform and equal. And testimony, it was clear that this was not an estimate of value. This was not a use PAT valuation. So at this point, Board of Tax Appeals and the district court, the only use PAT valuation they have for fair market value is from the PVD. Now, there is testimony, 2 expert witnesses from the Department of Revenue and one, Mr. Barbrich, with the recs. They offer opinions as to uniform and equal as applied.
I have a couple of other housekeeping things, so bear with me for a second. District court opinion talks about there being 18 rural electric cooperatives, but I kept reading 16 in all the other documents. Surely we know the difference.
Yeah, my understanding is that there are 10 actually there's 18 altogether, and that the 8 are parties in this litigation.
So the district court is right. There's 18, 10 in and 10 out. Okay. Another housekeeping question is you just added to the record on appeal, the rural electric cooperatives expert report that was given to the district court. Okay. There's a reference from the rural electric cooperatives that report is virtually identical to the report that was given to BODA. Do you agree with that?
I do, Your Honor.
Third question, then I'll shut up. And this is going to sound facetious, maybe. But in looking at the order of the district court, the remedy that it's ordering, which is to give appropriate consideration to the adjustments to the current methodology, can't figure out what that means. Are you really and I guess it gets down to, are you really an aggrieved party? Do you really think that there's something that you're being forced to do other than give appropriate consideration, which would be to look at this report and say it doesn't have anything to do with the uniform appraisal procedures that the statute requires, and you're done? Am I just being too cute by half? Or, so I guess the answer is, how are you an aggrieved party from the district court's order?
Justice Miles, we are very aggrieved in the sense, and I have 2 minutes and 30 seconds left, Your Honor. So I would ask for maybe a little bit of leniency as far as making some other arguments. But the fact is the big part of the district court's decision is it basically said the methodology employed by PVD or the director of evaluation can be fine-tuned. It can be better adjusted to reflect accurate value, fair market value. And I believe that that is well beyond the standard for unreasonableness, which is 621C8. And fine tuning is very much different than saying is this methodology employed by PVD so wide of the mark that it's unreasonable or implausible. Thing is the district court is basically saying, and we know to the dollar how this adjusts the valuation under the income approach if we are to consider a reduction in income by this accounting concept created by the recs. So I believe it's a final order, and I think we've been aggrieved in the sense that, number one, PVD's methodology, its discretion as an agency, its expertise that's been granted to it by the legislature in this special capacity to set methodology has basically been co-opted by the district court, and it's effectively acting as a policymaker. Not to say that it's been unreasonable, but to say you need to fine tune your processes. And effectively the court, and more importantly, even if we go back and consider it in the context of this one case, 2019, 2020, we have many years of appeals that are pending afterwards, right? And the concern is that if PVD is forced to make this adjustment to its methodology or its agency expertise on this arbitrary classification or subtraction from income, my concern is that the income approach no longer becomes really a valid mechanism for valuation with regard to this industry. Because in the context here, they're basically saying that an MSA adjustment, which has nothing to do with the relationship between the customer and the rural electric cooperative, it doesn't reflect what is the cost of it, the expense, the operating expenses of the RECs, because they never pay it to the wholesale distributor of electricity. When they deal with their customer, a customer that has to use this service because of their physical location, they send a monthly invoice to the customer and they say, this is what you pay for electricity. Now, the RECs don't make it clear in that monthly invoice that guess what? A portion of this is going to your equity interest. Congratulations, you're buying shares or more equity interest in a company like Evergy. No. In the invoices received by the customers, it's basically saying use this much electricity and you're going to pay this much. Now, do these people?
Can I
Yes, sir.
just jump in here? Your discussion of the invoices is a helpful bridge to my question, I guess, which is, I understand this goes beyond the technical legal questions presented, but I am trying to wrap my head around the motivations or incentives that lie behind the economic decision-making of the parties here. What is, in your view, the impact on the incentives of the RECs if you were to prevail? And then I guess the flip side, what is the impact on the incentives if the RECs prevail?
Well, Justice Stiegel, I can't really speak for the initiative, I mean, the interests of the RECs, right? But what I do want to say is that these are internal accounting business decisions. And when I'm conducting evaluation to the income approach, I'm looking at operating expenses, day-to-day expenses, not the below the line treatment or accounting classifications within that specific.
And I understand that, but I guess I'll just, maybe you don't want to answer the question.
No, please.
But I'll ask it again. Like, just in a global sense, surely you have an understanding of how these market players react to different legal rules in their economic decision-making. We need to make a rule here. I'm trying to discern what impact that rule will have on the incentives of the different players.
Sure. If you rule in favor of PVD and reverse the district court, what that's going to tell the RECs is that this conceptual concept of non-value creating income is not a mechanism for relief or lower property taxes.
So would I be correct to say then that it creates an incentive to pass the credit on to the ultimate consumer, which reduces the equity held by the utility? Is that the incentive that rule would create?
I believe so. It would basically return or lower the costs in that year, in that month for the cost of electricity.
Okay.
That would have a effect of reducing the price, or it would be another incentive. There's other issues.
And it's a trade-off, right? It's a trade-off between returning the capital to the consumer versus retaining capital in the, call it a rainy day fund, call it whatever you want, but retaining the capital in the utility, which then would become taxed.
Justice Stiegel, I think that question gets to the heart of this case in a sense that I don't believe that's an immediately, just because their bylaws say that it's to be treated as margin or profit upon its receipt. The REC doesn't know what its margin or profit is when it receives that payment for the customer. Even the REC's own witness, Mr. Wellwig, said, yes, these capital distributions, capital allocations, these capital dividends, they're income once upon a time.
So, because this is a public utility, it strikes me that some measure of sort of policy of common good is in play here. Was there any testimony or any suggestion in any of the proceedings below that this incentive would destabilize the financial stability of the RECs?
I do not remember there being.
And not because they're having to pay a tax, but because they're being incentivized to pass through the credit.
No, I don't believe it's a credit. I don't
Well,
believe
okay,
it's
I
a
may have,
credit end of the year when there's a.
maybe
profit
that was the
overall.
wrong word, but I think you understand my question.
Right. I mean, the thing is I just want, and basically setting up net operating income, I want a reasonable way of determining what revenue is. And this accounting, this is a process where it is more form than substance. And effectively, I want this court to consider the essence of this transaction and that the customer who is forced to be a consumer of electricity from these companies is basically paying for its use of electricity. Now, to say that it now has an equity interest and somehow that should reduce income, well, in my brief, I make it very clear that that money may never come. Well, there's no interest basically retained by this customer if the company, the REC, uses it for 19 or 20 years.
There could be an argument made that the interest retained by the customer is a financially stable utility that will not run the risk of essentially being unable to provide services. Was that argument ever made?
I think I'll let Mr. Musil obviously speak to that issue in more detail. I don't think there's any evidence that any of these RECs, 18 going out of business, or that this issue will basically destabilize them as being able.
That was
to
my
provide
question.
services.
Thank you.
And then let me, oh, go ahead. I don't want to interrupt your final comments on his questions. I'll let you wrap up and I have a couple questions.
I think a big part of this MSA treatment, as far as for the RECs are concerned, has to do with their ability to secure lower interest on some government subsidized loans. And that's a big part of why they classify it the way they do. I just don't think that's an above the line conceptual item that should affect net operating income.
Okay, my question is on the statute that creates these procedures for appeal, 74-24-26. The trial de novo, which will include an evidentiary hearing at which issues of law and fact shall be determined anew. Tell me how we interpret that statute in a way that still has preservation as a relevant question between the BOTA appeal to a district court proceeding. In other words, do we still have those same prudential issues despite this trial anew sort of concept? And explain how that works in terms of a statutory construction.
So that's the struggle, Justice Wall, is the concept of like in the matter of Walmart, right? You've basically said, hey, a lot of issues regarding valuation should be considered by the Board of Tax Appeals. Those are fact issues, or we shouldn't get into how you should do something specifically. But this case is in a sense where the court not only basically said fair market value needs to be reconsidered or fine-tuned, it basically said the overall methodology employed by PVD, effectively sort of like its guide, needs to be reevaluated in light of the court's opinion. And You know, the issue is that may address it with regard to 2019 and 2020. But, you know, there's obviously a lot of litigation on the other side. And the thing is how this court rules will also have an effect on those other 10 recs, right? Because if they see that this court has basically recognized this margin stabilization, this wholesale distributor accounting classification, that's not really associated with revenue or net operating expenses of the rural electric cooperatives, they're going to do that too. I would if I was their attorney. I'd recommend it to them. And the fact is that's going to have an overall effect of reducing, and that's going to basically, if they're effectively saying that the profit or margin is defined by the co-op according to their bylaws and that should be reduced, that's an internal business decision, affects or can be reduced from revenue.
I understand the substantive argument. I guess my question was more, I took it to read that you took issue with the fact that was even in play at the district court level. And I assumed it was because of the statute, despite being de novo review, still didn't mean you can just, tee it up all anew without having BOTA have the first bite at the apple, so to speak.
The thing is that gets us to 621C, right? And the four issues raised by the district court as far as review. I believe a district, again, getting back to this concept of in the matter of Walmart, the thing is you have the specialized board of tax appeals with an appraiser, an accountant, and an attorney. It's like a joke, right? Start of a joke, a punchline. But the thing is, and then you have to move the district court, right? Now, fortunately, in this case, we had a pretty sophisticated judge who understood property tax laws. But all of a sudden, we move to de novo district court review. And with regard to the issues raised, it's de novo, right? New evidence can be presented, new legal arguments can be made, but that's limited to the arguments that were raised at BOTA and ruled on. And in this case, I argue the recs in this case basically made this a case about uniform and equal. And their expert opinion report at BOTA was not a valuation. It was not a USPAT valuation. So BOTA basically sees in front of it one USPAT valuation and rules accordingly. And I don't believe they can come back and now argue fair market value at the district court because I don't think it was sufficiently argued below.
Justice Wall talked about that being a preservation. To me, it's a jurisdictional issue. Because you have to exhaust administrative remedies before you get into the judicial system. So you can't raise new issues that weren't raised before BOTA. Does that make sense?
Yes, Justice Biles.
The district court has a couple of references in about that timing doesn't matter in the context of, when the member it's this capital account, whether it's something, it's real money or not to them. It says timing doesn't matter. But the whole notion of valuation of property is a snapshot on a particular day for the year. And so then every year changes. So was the district court sort of ignoring that whole concept of valuation by saying timing doesn't matter when we're talking about these, patronage accounts?
I believe so, Justice Biles. I think that's a big part of this. The fact is that there's a conceptual aspect to the income approach, right? With comparable sales, you have actual numbers of comparable properties. With the cost approach, you basically develop a real world inventory. You're going to use the income approach. You have to basically invest in its conceptual nature and follow those rules. And I understand that some of those things might result in some variance, right? In overall valuation. Like in this case, some of the recs had their valuations go up. Did their real personal or tangible property, did it all get replaced and become suddenly more valuable? Simple argument could say no, but the thing is that is the concept. If you're going to basically rely upon the income approach, which was the lowest valuation indicator determined in the USPAT valuation, we did a cost approach that was much higher. But if you're going to commit to this conceptual approach of the income approach, you have to follow its rules. And those are rules that The recs understood both before 2019, they understood how PVD would basically consider income. That we would basically look to the substance rather than to the form. And they still made those decisions. They must have did them for other reasons. But hopefully I answer your question, Justice Biles. I've used up my time. Is there any more questions? Thank you.
Greg Musel representing the appellees here, including Free State Electric Cooperative Incorporated. May it please the court, Mr. Smith. You're interested in rural electric cooperative taxation early on a Friday morning. The question here is, did Judge Watson at the district court level, after hearing 3 days of testimony, more than a dozen witnesses and dozens of exhibits, have substantial evidence in that record to determine that PVD had not applied 79-5A04D properly, which requires PVD by its choice to value these RECs based on utility operating income capitalized in such a manner and at such a rate as to be just and reasonable.
Let me
That-
stop you there.
Yes, sir.
On your state law violation claim. I want to make sure we agree that just because you asked for de novo review at the district court level does not let the taxpayer add issues that were not considered by BODA. Do we agree on that or not?
I agree on that, and I'd be happy to speak to how valuation
That's fine.
was raised.
And that would be jurisdictional as opposed to some sort of prudential preservation.
That's correct, Your Honor.
Okay, I just want to make sure we agree with that.
Let me forget my outline and speak to some of the things that you raised that you're interested in. The first thing on valuation, when a property taxpayer files an appeal, whether it's to PVD or the county appraiser, first of all, understand it is most likely a layperson. It is not going to be a lawyer. And I don't think we should require pigeonhole pleading, which is what PVD has said. You didn't specifically mention, I am opposed to the valuation of this property, even though valuation and NOI, net operating income, is mentioned in the first filing to PVD. When we get to the Board of Tax Appeals, my opening statement, I mentioned 3 times, and I can give you the record sites if you want, about how our expert is going to speak to valuation, how our witnesses are going to speak to valuation. Don Helwig, who testified on behalf of the RECs, spoke to valuation and how this adjustment affects individual valuation. Angie Dick Erickson, who's the CEO of Twin Valley, spoke to that. Now, if you look, and I looked last night, if you look at the record, valuation, values, valued, values are mentioned 244 times in the BODA record. Now, some of those could be with respect to the uniform and equal portion, I admit, but 244 times in the Board of Tax Appeals record, the word or subject of valuation occurs.
But nowhere in the BODA transcript that we have in the record. Well, actually in any of these, either one, does anybody mention whether this income approach methodology that's being used violates generally accepted appraisal procedures? That's the statutory standard. So to say that the statute's been violated seems to me that somebody somewhere has got to say, we've looked at this income approach being used by the division and this ain't it. And no one said that.
I believe, no, I don't agree, Your Honor. I think if you fairly read Mr. Barbarich's testimony and his report, which I will note was admitted by stipulation and without objection at both BODA and the district court. He speaks to the fact that when you do this adjustment the way PVD does it, he's speaking to generally accepted appraisal practices.
He never mentions the standard. He never mentions that phrase. In either the report or in his testimony to BODA. I've read both.
I believe you, Your Honor. I don't think you can fairly read the context of his report and testimony without indicating as a person registered by the American Institute of Certified Public Accountants, which is his standard, along with some other qualifications that are in his CV, that anything other than that makes sense for why he's testifying.
And when the district court put in its order that it was allowing these extra, I'm just going to call them extra issues, so we know what we're talking about, the state law claims. It quoted one statement, one sentence from the BOTA order, right?
Correct.
What the district court didn't take into consideration was on the first page of the BOTA order, BOTA says what the issue is, and it's uniform and equal. And it doesn't have anything to say about the state law standards. So it just seems like the one sentence that's being seized on by the district court to open up these other issues is contrary to what BOTA said on the first page of its order was the issue in front of it being raised by the RECs. It's hard to reconcile that.
In that first paragraph or the first page of the order from BOTA, BOTA says that basically that the RECs believed their valuation was, quote, artificially inflated, unquote, by PVD's development of the MSA. And then at the end, it said, you've not presented sufficient evidence to persuade us, quote, that the instant RECs were not appraised at their respective fair market value.
But you're leaving out the part of the BOTA sentence about the issue that says it results in non-uniform and unequal valuations of RECs statewide. That's the constitutional question that was raised, particularly when you look at the notice of appeal that went to BOTA from the cooperatives that also said our issue is the constitutional issue. It seems to me that that lines up much better than seizing on this one sentence at the end that the district court seized on. Because honestly, you know, we've seen lots of BOTA fair market value orders. And the one you've got isn't it. That's not the way they do fair market valuation. So again, trying to figure out whether the district court exceeded its jurisdiction by adding issues that weren't decided by BOTA, weren't part of the BOTA order, is really difficult to line up.
I think maybe this gets into, I think it's the Hansen case that talks about issues not decided by the administrative body. Because I agree with you, BOTA generally will have a section on, most of their cases are about fair market value, and they don't do uniform and equal. They did not here. And frankly, it would have taken them a lot of time and effort to do that. And they simply, I believe, took the one sentence and said, you didn't present enough. I don't know that we could have done any more because we presented everything the same at BOTA that we did at the district court. Same exhibits, as Mr. Smith admitted, it was the same expert witness report from Mr. Barbarich. If we were not specific enough, then that is my fault. But the evidence presented there gave ideas of valuation on each and every REC. And that's what BOTA had in front of it and chose basically to dispose of in a one sentence.
Let me ask one other question that's been bugging me, and then I'll leave you alone. I can't figure out how 77-621, which sets out the ways you can have judicial review of an agency order. I can't figure out how that aligns with the OVO process, because as I grew up practicing administrative law, 77-621 was there to limit the scope of what the district court could look at. But here, we've got this new evidence, you can come in, maybe not new issues, we've agreed, but new evidence can come in, you can make your case de novo. That doesn't seem to be compatible with 77-621's limitations on what should be talked about by the district court in doing agent. Have you given that thought?
I have, and I think this court has, because you decided the Bicknell case where you had a similar issue on a Kansas Department of Revenue issue on domicile. And you had a regulation and you had a district court decision that you then reviewed.
And Bicknell doesn't ever mention 77-621 in those
Right.
items.
But
And that's what Bicknell's the one that's the only case we've got. That's the one that I read it again last night. It sort of just puts the district court in Boda's shoes unless the parties relitigate the facts. And that's not a 77-621 analysis is my point.
we know why 74-24-26 C4B was passed. It was a legislative effort to make sure that taxpayers had a direct route de novo to the district court. I don't think there's any dispute about that. And then Bicknell follows that and says, okay, you get a de novo, new facts, new findings of law. If you combine that with the Hansen case, which was cited by PVD, but only part of it was cited. It was cited about how you have to give some deference, quote unquote. The next sentence says, we must be careful in granting that deference. Otherwise, we will undermine the ability of courts to perform judicial review. And I agree there's a tension between those, Justice Biles, but I think when you combine the adoption of 24-26 C4B and the notion that we are not going to give the same deference in situations where the agency hasn't prevailed in providing substantial evidence to support itself, or substantial evidence has been demonstrated by the challenger. And on the burden of proof, I may do it anyway, but I didn't want to make new law, so I didn't make the argument that PVD had the burden going forward. We accepted the burden.
It's just that initial burden. I mean,
Right.
the taxpayer usually carries the bigger burden.
Right. So we took on the burden at Boda and we took on the burden at the district court, and we believe we carried it in both places.
I want to clarify to make sure I understand your argument on that earlier issue about, and your exchange with Justice Biles about the new issue. It seems to me like there are maybe about 3 ways this could be looked at. I think they're probably overlapping, but one would be that fair market value is always the issue, that valuation. Second would be that the uniformity is fair market value is inherent or intrinsic in the concept of uniformity. And the third is, no, we very specifically made clear we were challenging fair market value. Which of those are we looking at all 3 of those? Is it one?
I believe it was clear to both tribunals, Boda and the district court, that valuation was a direct issue. But at a minimum, you cannot talk about fair and uniform without raising the valuation issues and arguing and presenting evidence that the valuations were wrong. And that's what we did. So if we didn't make it explicit enough, I think it is clearly implicit in the record at Boda and the record I guess the record of Boda is what matters. So you can bring it up to the district court.
Is it fair to say that your argument was, look, because your valuations are wrong, you are creating a uniform and equal problem? In other words, if you fixed your valuation, we would have no uniform and equal problem because all the RECs would be treated the same. The only reason they're being treated differently is because they handle the so-called credit differently. Am I understanding that correctly?
That is exactly right. If our position had prevailed, it would apply to all the RECs.
So your argument, sorry to interrupt, but your argument is that the valuation question was completely subsumed within the constitutional argument.
I don't think that's right. I don't think that, I mean, the value,
Well, there's no way you could prevail on your constitutional argument unless you proved the valuation method was wrong, or the valuation being done by the state was wrong, right?
that is correct, but we could have prevailed on the valuation issue and still lost on the uniform and equal issue.
Sure,
That-
but
that's
the
a distinct
opposite is
element.
not true.
I think that's correct.
You can be you can violate uniform and equal and still come up with fair market value, right?
That's correct.
I mean, your process can still result in fair market value.
Right. And we could have prevailed on our values with some other, based on the evidence, without the court or BOTA finding that it violated uniform and equal, because that is a very high burden and requires some kind of knowing and intentional act to cheat a taxpayer, basically. And we knew that was a high burden, but we went into this because our valuations were dramatically different than other RECs and were wrong with respect to our RECs.
Let me ask you a question. So your opposing counsel said, in response to Justice Stiegel, about, I guess, what the interest would be is that you could secure lower interest on federal subsidized loans if you kept it in like an equity account. Would that be true?
This goes back to Justice Stiegel's questions about incentives.
Right.
Yes, these are member-owned, member-run cooperatives who have created bylaws under KSA 17-4601 at SEC. And those bylaws say we're going to take excess margins and make them patronage capital. We have to refund them, and they choose.
Right. Now, I understand that. But what I'm saying is, if you're getting a loan, is that one of the benefits, the incentives is that you get a lower interest rate because of this patronage account, or that, you know, that it's more stable, or that the money's in there.
It is, as in any business, the more equity you have, the easier it is to go get financing. And that gets back to Justice Stiegel's concern about, there was no evidence about instability of the current
Right,
REC.
But if an entity that is going to loan money makes a decision and says, if that money is in an equity account and can be used to support the cooperative versus that money, and even though it's owned by, you know, it's an equity account owned by the owners, if it's in that, you know, I don't know what I want to say, but in that form versus in the pocket of the individuals that own the cooperative, you know, we're going to give a lower interest rate because the money is right there.
You are
Right.
more stable and more financially
Right.
secure
Well, why should that be taxed?
because it's equity. And a point, Mr. Kahn, the expert that Mr. Smith touts in his brief, admitted that an equity account should not be included in an income approach. So if it's defined as equity and it's used to secure that, it's not, our basic point was, you get $1 of patronage capital, it is not the same as $1 of income. And that's why we never asked for this entire MSA to be ignored. We asked that it be looked at in a different manner with respect to your loan requirements and your ratios, so that you first had to secure the financial stability of your REC. That's all taxable. The margin above that goes into the patronage account would not be subject would not be included.
Is the patronage account interest bearing?
No,
So you don't make any interest on that at all?
no.
It is the basic point that your argument is that that money is a capital contribution, not income.
Correct.
Right. Okay.
And so
Okay.
I guess there's another way to skin the cat, so to speak, which is a member-owned REC could accept the credit as a pass-through refund on the utility bill and just require an X percentage of capital contribution to come right back.
It could through its board of directors.
And doesn't that get you in exactly the same spot?
Well, it would automatically, if it's received as, it could, I haven't thought of that before, but so they take the refund, they refund it to the customer.
I mean,
on a
yes,
monthly
this whole
bill.
dispute just strikes me as, I mean, it's important, don't get me wrong. I'm not denigrating the dispute, but it is somewhat semantic. You've got dollars that are sitting there, and the only question is it a capital contribution or income? And because of the unique way that the REC, you know, takes in and classifies the dollar, there's an ambiguity that has popped up. We can't tell. This is why we're having this whole litigation. You could do it in a much more straightforward fashion.
Well, perhaps it is straightforward now because every bylaw says exactly how those are to be treated.
Okay.
And that would be, I think, my answer, that the bylaws handle that. They're adopted pursuant to Kansas law, and they should control these member-owned utilities. And I thank you very much for your time.
Can I just ask one final question before you go away? And you may have answered this already in response to some other previous questioning, but I just want to understand the testimony of the Barberich expert. During, I think it's in record volume 2, you're talking about the 3 different options for handling the credit. And then you ask about what does that mean in terms of valuation? He says, from a valuation perspective, under fair market value, it should have no effect. It should have equal effect amongst similarly situated properties. So it does sound to me like the argument on uniformity is sort of subsuming the fair market value argument. It's that they all should be treated, it should have the same effect. There should be uniformity. And the fact that it doesn't means that there's a fair market value problem. Am I misconstruing the context of this testimony?
Trying to remember the context because I saw that quote. If you do this in one of those 3 ways, what I think you say, it shouldn't have the dramatic effect on valuation that it has.
Right. Right. It should be uniform. It should have the same effect on fair market value, regardless of the treatment of the credit.
Yes.
And my problem with this exchange is no one says that the way the department is doing this or the division is doing this violates generally accepted appraisal procedures, which is the statutory standard, right?
That is
No
the
one
statutory
said
standard. Nobody said those magic words, Your Honor.
Do they need to?
I think we have gotten away over the centuries from pigeonhole pleading or magic words. And the context of all the record here is that valuation was an issue. It was part of the uniform and equal question because you can't escape it as part of the uniform and equal. But it was part and parcel of the BOTA record and part and parcel of the district court record. And I believe the BOTA record allows us to raise that in the de novo trial. Thank you.
Counsel, I know you have limited time. I'm just going to jump right in. This will be my only question. You heard the exchange. Would you agree that if an REC passed the credit through on the bill to the customer and through their bylaws or the decision of the board of directors added a capital contribution charge, that would not be taxable under the income approach?
Well, it depends. If it's communicated to the customer in the monthly invoice and it's not.
Yeah,
in
it's
this
a
case,
separate line item on the bill. It says capital contribution.
That's not the facts in this case.
I know. I'm just trying to understand
That
the
might be,
impacts.
that might be a reasonable consideration. You have to understand, though, that that money is still available to the co-op to be spent for operating expenses, to basically be spent to improve
Right. I'm
distribution.
just trying to understand if the position of the state is that we will not try to tax capital contributions
If it's
under the
made-
income approach.
If it's made clear in the year of payment.
That's what I mean. Yeah.
And it's made very clear to the customer. See, in this case, it's not made clear to the customer when they pay the invoice, nor at the end of the
Yeah.
year
No, I
when they do capital
I appreciate that.
contributions.
I think I
Make a
understand.
distinction.
But here's the way I've been thinking about it, so correct me. So because the 8 RECs, commissioners here, taxpayers here, because they don't give the customer a break on how much they're charging them for electricity, when that customer pays the bill, that money goes into the cash drawer. Cigar box, I mean, just the cash drawer. And that's what the income approach looks at. When, maybe said that, their bill is bigger, their customer's bill is larger, so more money's going into the cash drawer than when you give the customer the credit and they pay less money because they got the credit on their bill, that cash drawer has less cash in it. And so when you all go look at the cash drawer, there's more money here and there's less money here.
Correct, Justice.
And then you take the expenses. And the other question I had was the KEPCO, when they give the credit that starts this thing, or when they give, does that reduce the REC's bill to KEPCO for the electricity? See what I'm saying?
Sure. My understanding with KEPCO, and I've got some issues I want to deal in rebuttal, but
Well,
my
questions are.
the thing about KEPCO is that that is basically an estimate of at the high end of what they may charge these RECs, right? And that's not in reality what they charge them.
My bottom line is the relationship between KEPCO and the REC does not reduce the expenses of either REC.
Right.
It's just more cash coming in because
More
of the way they bill their customers.
Right.
Okay, fine.
I'm saying that the revenue calculation is completely between the consumer, the member, and the local rural electric cooperative. It's not generated by abstractions between the distributor and the rural electric cooperative. And that gets to Justice Standridge's questions. And I'm moving from a PVD to more of a tax person here, but the idea is that we can't advance to go collect $200. This payment of money needs to go through a revenue consideration. It needs to be factored against operating expenses to develop net operating income. And then you get down to EBIT or EBITDA, and then you get down to net earnings. And that's where it becomes margin and profit. And the fact is that we want the court to look at the substance rather than the form and say, this has to be originally treated as income, because that's what it is. It's available for the RECs to spend and use. And I'd also, again, I'll just follow up with the issues regarding jurisdiction and whether it was raised before BOTA. You know, the issue here is that this isn't a small dispute regarding the size of a garage in a property valuation residential cases. You have sophisticated parties with very good lawyers that have lots of capital. So when they prepare a pleading, when they make an appeal, they know what they're doing. And in this case, the primary expert presented to you, Mr. Barberich, the issue here is they had a USPAP problem, right? Under the ethics rules of 1.4 USPAP, you can't issue a valuation appraisal if you have a bias or if you have a preordained position on an issue, right? Well, in this case, and I'm not being pejorative to Mr. Barberich. I mean, he advocated for these same tax representatives. He advocated this issue on their behalf as a tax representative for him in 2017, 2018. So what that means is that the primary witness by the RECs had a USPAP conflict of interest. So he had to be very, very careful. And he couldn't tell you that this is a USPAP estimate of value because he wasn't presenting an opinion in that capacity. So he had to limit it into the argument of uniform and equal, which is a broader idea. So this isn't something accidental or we're not reading far enough into the pleadings.
Is that conflict developed in the record?
Yeah, it was developed in cross-examination, direct and exact. It was basically there's a lot of go between the REC direct and the PVD's cross-examination, making it very clear because Mr. Barberich kept getting close to that line, saying, hey, this is my opinion of value, this and that. We had to keep bringing him back and say, no, I can't provide an estimate of value. I'm not a licensed Kansas evaluator. I basically acted in a capacity as a tax representative, sitting in my same shoes in front of BOTA, possibly, definitely in the informal hearings. And so because of those issues, he wasn't really in a position to basically offer an estimate of value. And he didn't go to the trouble of a cost approach or comparable sales, which are other requirements. Now, with regard to Mr. Musil's comments about Mr. Can and his basically acknowledgement that this wasn't a revenue issue. The fact is we're dealing with classical, general accepted appraisal practices here, and even general accepted accounting practices, right? And it's classical to say when a customer pays you revenue to consider that income. That's the normal default standard. And what the Rex asked BOTA and what Rex asked District Court in their quasi-valuation claim is to adopt this novel concept created by a tax representative who now is turned into an expert witness. And we believed in that capacity. I understand one of the only issues in this case where there is no deference given is the credibility of the witnesses, right? I argue that everything else, basically deference, this court can basically consider it unlimited. But as it relates to the credibility of the witnesses, the district court only evaluated that in front of Barbich, Can, and Knutson. It didn't comment about credibility in relationship to the use pat valuation presented by PVD versus Mr. Barbrich's maybe, maybe not valuation opinions. I have nothing further. Is there any questions?
But when that testimony of Barbridge, you know, it maybe it comes close to the line, doesn't, you move it back. But when you're arguing that the treatment of the credit should have no impact on valuation, and then there's other evidence indicating that it does in this certain one treatment of the credit, can't we infer from that that that's a challenge to the valuation methodology, or what would be wrong with that?
Well, what would be wrong with that is the fact that when big sophisticated parties like big commercial entities or utilities like this, they want to present an issue of fact for this court in considering valuation. So you have competing use pat valuations. And there you dig deep in to see, well, who evaluated it correctly according to uniform standards. That's not the context for you here. Right. Thank you.
Thank you to both parties for your arguments this morning. The court will take this matter under advisement. We say that, and what we mean by that is that later today, even, we will begin discussing this case. Those discussions will continue until the seven of us have decided, at least preliminarily, on outcome and rationale of the case. The case will then be assigned to one of the seven of us to write a draft opinion. If we are not in agreement, there might be some opinion, some of us writing concurring opinions, which would be an opinion where we agree on the outcome, but do not necessarily agree on the rationale, or at least a part of the rationale. Some of us might dissent, meaning that we disagree with that outcome. All of those opinions will be circulated among all seven of us, edited, usually fairly significantly in that process. And there will often be some back and forth. And then once we are in agreement on a final process, that will be filed with Mr. Shima's office, the clerk of the court, as well as published. It will be available on our kscourts.org website for everyone to be able to review and see the reasoning of the court. We also release a press release when we do that, so that the public can know that that opinion is now available for reading. That process usually is done on a Friday morning. And so that's typically when that culminates. So that explanation, thank you, counsel. We'll now call 125-534 in the interest of A.S., a minor child.
May it please the court. Chandler Colgan, attorney for appellant father H.S. Thank you for the opportunity to be here today. This case is before you today on the grant of a petition for review on the termination of parental rights, where father appeared at the termination hearing via Zoom. At the time, father was in federal custody and unable to appear in person. The state had made efforts to transport father back for the termination hearing, and those were unsuccessful.
What efforts were made?
Your Honor, the entirety of the record on that is volume 3, pages 12 to 15. Based on that, I know the state had made multiple attempts, phone calls, had left messages, and none of those were returned.
It was more than I had looked at, but it was more than one phone call and message.
As I understand it, yes. I was not trial counsel, but from the
Okay.
record and my experience with the county attorney is they usually make significant efforts
Okay.
to try to secure an in-person appearance.
Okay.
Did the father make any attempt to file something in federal court, such as a writ of habeas corpus ad testificandum or anything to the federal authorities that would get the possibility of a federal order to transport?
Based on the record as filings in federal court to secure.
The facts in Re adoption of BJM are remarkably similar to this case, with one distinction. There, the parent requested to be present and was denied that chance. Here, we have no such request, and in fact, the father's attorney, when asked by the court, "Are you ready to proceed?" said, "Yes, we are." How does that affect our analysis?
I think one of the issues here was the court was not set up for in-person and Zoom. Parties just accepted as a fact that the only way there was going to be any presence by the father was via Zoom.
But did they? I mean, I understand that's how the issue is worded, that the court denied his ability to appear. But this was during COVID. And during COVID, there were many practical problems that came up that had to be addressed. So, for example, if we don't know how the parties are going to visit with their attorney, they might be advised, if you want to visit with your attorney, let me know, and we'll clear the courtroom, and you can talk to your attorney however you want to do it. You know, there were practical things that came up, as opposed to a legal problem that might need to be addressed before you go on or before something else happens. So how do we know that it's not just a practical problem that we're looking at that is not a big deal, as opposed to a legal problem that the district court really needs to stop, address, and resolve?
In terms of the practical issues, court was not set up for in-person and remote Zoom here.
But isn't that a practical problem?
It was. The legal issue is we're dealing with the fundamental right of a parent regarding termination of their parental rights. And I think in this instance, this is a very conscientious district court. And in trying to accommodate father to at least have him observe the termination hearing, may have walked into a constitutional violation.
We may have, but the constitutional right is the constitutional right to be a parent, to parent. And while part of that might be the father's right to testify, that can be waived, can't it?
Yes, it could be.
So isn't it reasonable for the court to interpret, yes, we're ready to go, as waiving the father's right to testify?
I think it could be, but there was no affirmative waiver here. Court didn't take any other steps to ensure that father was waiving.
And in addition, is this just the right to testify or the right to participate, period?
Right to participate. He was merely an observer. He couldn't interact with his attorney. Cross-examination or testimony that was presented, merely dialed in on Zoom and watching.
But do we know he didn't have a microphone available to him?
From the record, it is unclear, but there was a comment when I went back and looked at the transcript, at the end of the transcript where the judge was setting the hearing for the next, for her decision in the case. And she made a comment that, as I paraphrase, that, I'm not sure he was able to hear me or the witnesses today, but he'll be able to hear me and my decision. I can provide that cite to you. So it did.
And part of the problem here too is that he didn't ask for a continuance, correct? And he didn't ask for accommodation for a hybrid hearing, which both of those things might have been able to be set up if the court was aware.
That is correct. And again, I think it just went to, when you look at the transcript and the judge's comments, that this is what you're going to get. You're going to be an observer, and which certainly was appreciated. But at the same time, I think there could have been additional steps to have an active participant there.
Is there any indication in the record, because I couldn't find one, that indicates the father wanted to testify or what he would have testified to if he had if he had testified?
No indication in the record. When I was appointed as appellate counsel, I determined it was an issue that needed to be raised in front of this court.
There was also a discussion in the briefs about the father communicating with counsel during the hearing. And the court inquired about that, or counsel inquired about that, being on Zoom, able to get to a private room, which is available on Zoom. And counsel indicated, well, we already talked earlier. That be interpreted as, no, that's not necessary, Judge?
I don't think so, Your Honor, because that discussion was between counsel and his client, and that was before the hearing commenced. There was no opportunity during the hearing for him to either contact his counsel or have a private discussion with his counsel. So I think some of the cases discussing Zoom really go into depth on that, about the importance of being able to, during the proceeding, contact your attorney and say, here's my input, here's what I need to discuss with you.
So how are we to interpret counsel's statement of, yes, we're ready to proceed, knowing all of those conditions or those aspects were in place?
I think we're ready to proceed under the conditions that the court has essentially imposed on us, that my client will be an observer, and as opposed to cutting him off from Zoom and the hearing going forward.
So what are we supposed to do with the fact that there was no objection or no further request for accommodation?
I think the court needs to look at the fundamental liberty interest that is involved here, needs to look at facts of the situation with this being during COVID, and also needs to consider the growth of Zoom and the use of that and how that has made perhaps a class of parents that might not have been able to appear and participate in termination hearings might allow them that interest and that ability. And I think that's very important to protect.
I just have one final question, then I'll be quiet so the others can have a chance. This petition for review was done pursuant to Supreme Court Rule 8.03A, which is a summary PFR limited to 2 pages. There was nothing in the PFR that addressed the Court of Appeals decision not to preserve or not to exercise its prudential discretion to take up the constitutional issue because it wasn't preserved below. And there was no discussion about what we do with that in the petition for review or in the briefs. So what are we actually reviewing here? Are we reviewing the panel's decision not to consider the father's due process claim for the first time on appeal which would indicate we're looking at abuse of discretion standard of review? Or are we reviewing the due process claim itself as if the panel didn't exist, such that we are deciding whether we think we ought to issue prudential review?
I would submit it's the constitutional claim itself, Your Honor, for de novo.
So what do we do with the, with the Court of Appeals decision? Do you think there was an error of law that they committed in deciding not to exercise prudential review?
I think in failing to consider that, because it was not.
But there are three things that we look at in deciding whether or not to exercise prudential review. And the Court of Appeals looked at the constitutional issue and whether or not there was a fundamental right that was denied. And they made a decision about that. Did they make a mistake of law in their decision?
Consider it, they never actually.
Do you think they made an error of fact?
This court in its grant of the petition for review did issue three questions. The first was regarding, oh, I do see my time has expired. But
Want to briefly summarize what you would say there?
thank you. I would say this court should take up review because this is not a fact, it was not raised in the district court. It's not a jurisdictional bar. This court has discretion to consider that issue, especially in light of the fundamental rights that are present in this case. And I also think, as we've discussed, that the implementation of Zoom, I think, is important to provide some guidance to the lower courts on what those standards should be. And I think that would increase the access to justice for some parents that perhaps might not be able to appear in person. And I think that's a very important issue. So, thank you.
Filing your 803A summary submission, you did so based on saying there was dispositive controlling authority. What did you have, what authority did you have in mind?
That would have been under Rule 6.02A, that this court. But the dispositive authority under the 14th Amendment of the United States. Father wasn't allowed to testify and merely be an observer.
So it was more the U.S. Constitution cases, not necessarily a Kansas decision that to us as your on-point dispositive case.
Yes, sir. Thank you.
Morning, Your Honors, and may it please the court. My name is Ashley Hutton. I'm the Sink prosecutor and an assistant county attorney with Leavenworth County. I know that the panel is very familiar with the and
Can
so
I just ask you right off the bat?
Yes, sir.
That how would this be any different from an in-person, everybody shows up in person for a termination hearing and the court orders the parent who's represented by counsel to sit in the gallery or to watch on a closed circuit television, but not to be actively engaged with counsel throughout the proceedings? Is it a similar, what's wrong with that comparison?
well, in that case, Your Honor, I think the practical issue that was presented during this case would not exist. In the fact that obviously, if the parent was able to appear, they would be,
Yeah, I know there's not a good reason it would happen in that regard, but practically speaking, isn't that the same sort of impact here in
Well-
terms of the right to participate?
I would agree, Your Honor, but in this situation, and perhaps I can set the stage, so to speak. I was the trial counsel present, and at the Zoom hearing, the father was present via Zoom. The judges had her desktop. She was able to see and hear the defendant. He was able to see and hear her. So if he had at any time wanted to speak to his counsel, he
Could you
could.
clarify that? I don't want to call it the biological
I apologize.
father.
The
Yeah,
father,
neither
yes.
Defendant.
I apologize, sir.
Yeah, could communicate with the court
Yes, sir.
verbally?
I believe so,
and-
sir.
You believe so, or he could?
Yeah, this is kind
So
of
he-
important.
I apologize, Your Honor. Judge Loudon was speaking to the father at the correctional facility and did speak to him to make sure that he was available via Zoom and that he did have the ability to speak.
Clarify, he had the ability to verbally and visually communicate with the court during this proceeding.
With the judge, yes.
Not
How
his
is that?
attorney,
Okay, I
but
just wanna
the
know.
court.
Attorney.
How is that the case? I mean, as I read the record, at least, that there was a sort of a pre-hearing. Can you hear, like, you're on Zoom and like you can hear, but the judge made it very clear. I mean, the judge said, this is an in-person proceeding. I allowed for the Zoom link, so at least he can observe.
Yes.
That to me is very clear that nope, you can't talk. You are like someone sitting in the gallery. You're an observer. And that's by my good graces that I gave you this Zoom link. Doesn't that, I mean, that's how I read it. How am I wrong?
And I would not indicate that you would be wrong, Justice Siegel, more along the lines that I think the judge's I think the judge's statements were taken in a much more finality or a stern sense than I believe she that she meant them to be
Well, we look
taken.
at the actual words in the transcript and you might be right, but when judges, if this is an error of law, we don't say, oh, it's okay because you didn't mean it.
Yes, Your Honor. I understand.
So how is it not an error of law?
Your Honor, I don't believe that it was an error of law based upon the fact that he had contacted his attorney earlier in the day. He had spoken with him at that time. He was able to speak with his attorney prior to the hearing, as well as the fact that, again, as Justice Wilson pointed out, at no point in time was the affirmative statement made, I would like to testify.
Do you think that those arguments would carry the day if this was a first-degree murder trial?
No, sir.
What's the difference?
Well, this is a civil law case, sir.
I understand, but
Due process.
the due process rights at stake are essentially identical, are they not?
Yes, Your Honor, I would agree that they are.
Just one more point of clarification. When Judge Loudon said observe, was the word observe include participate or what you were there?
Yes, sir.
What's your understanding of what observe mean? And I understand words have meaning and we're talking about participation versus being a mere observer, but what's
Yes,
your
sir.
understanding of kind of the environment at that peculiar time? What all struggling with, what does that mean?
Yes, Your Honor. And I would base that on my experience that I've had with Judge Loudon and the Zoom hearings, which we were having relatively regularly at that time. But basically that to be present to observe the hearing also involved if he had time or a time frame in which he said, I would like to speak with my counsel, then judge would have stopped the proceedings and allowed him to do that.
How is he to know that when later, following the passage I read, the words I read earlier, Judge Loudon says, so at least he can kind of see and hear what's going on. I mean, how is someone to take from those words that, oh, I get to participate.
And I believe that the reason why she was saying that he could somewhat hear and participate, kind of hear and participate, was based upon the fact that the way that the desktop and the video capabilities were turned at the time, that it was not a clear shot. It was basically a,
Right, and what she says is not, she didn't say kind of hear and participate. She said kind of see and hear. And so it's almost as though like he's barely even an observer, let alone a participant.
again, Your Honor, I base the fact that he was able to see and hear, and that, again, we had used the technology in that courtroom previously. There had been, we were able to confirm that that father could hear the proceedings going on, and that he was and aware that his counsel was at counsel table, which of course was not next to the lectern. While I recognize, Your Honor, that his participation certainly is more complicated, and he would have had to take more steps than he would he have just been sitting next to his counsel at table. But he still would have been able to interrupt, ask questions, or ask to speak with his counsel, break out in a Zoom room.
So let me kind of take up from there and just ask you to assume with me for purposes of my next questions that there was a due process violation here. If there was a due process violation, do you agree that it's a structural violation, or do you think it's amenable to a harmlessness analysis?
Your Honor, and I would, in fact, use Chapman v. California. I do believe that it was a harmless error if an error did in fact occur. One of the things that I noted in my petition is that there is no harm stated, other than the fact that his parental rights were terminated.
Well, when we conduct when an error is structural, that relieves the party asserting the error from proving harm. That's what a structural error is. We have Court of Appeals decisions, I think, that say in a termination proceeding, if there's a denial of the right to participate, testify, it's a structural kind of an error. Are those wrong, those cases?
I don't believe so, sir.
Okay, so then my final question is, assuming a due process violation, assuming it's structural, shouldn't that impact our preservation rules? I mean, I'm not sure we've ever addressed this question before, but should the fact of a structural error change the way we look at preservation or not?
And Your Honor,
And the reason it might change it is because with at least certain kinds of structural errors, it's essentially a king's X. And in other words, you have a constitutional error below that entirely undermines the proceeding, which effectively it can't effectively eliminate someone's ability to even preserve the claim. So it just seems to me there's at least an argument to be made that where there's a structural error, we really shouldn't be looking at our traditional preservation rules. Just wanted to give you a chance to respond to that.
well, Your Honor, I do believe that in regards to the due process, obviously the court has to take those into more stringent consideration. And with a structural error, it would make more sense. I do think that in that particular situation, it would make sense to address the preservation issues separately, or to reassess whether or not those are actually being used in the correct manner. Because obviously, if there was a situation, as you said, Justice Stiegel, a king's axe, so to speak, that would be a due process issue that would make it impossible for anyone to bring forward that issue, that error. And that's obviously not something that court would want.
Do you think under our current rules, if the Court of Appeals chooses not to invoke an exception to the preservation rule. And they do so even if that's a proper exercise of discretion. Is there anything in our rules that would prevent us from reconsidering that question anew? In other words, well, maybe our court will invoke that exception, even if the Court of Appeals properly exercise discretion to decline review.
Well, could you, I apologize, could
Yeah,
you?
sorry, it probably wasn't a really clear question. I'm just asking, when an issue comes to our court and the Court of Appeals said it was raised for the first time on appeal, and we're not going to review it. And now it's before our court, is our focus limited on whether or not the panel erred in making that decision? Or do we also have the option under the rules to look at it brand new and say the Court of Appeals maybe didn't want to review it anew, but we do because we think another exception fits squarely?
Well, Your Honor, I would state that I do believe that.
In other words, do we have to find error below to even get to the substance of the issue?
And I don't believe that there was an error in the,
Of course.
in the Court of Appeals choice or decision. And I think that I understand that each court and their own decisions is somewhat sacrosanct. So I would say that at this point, if the Supreme Court were to take up the substantive structural issue, I have no doubt that that would be something that could potentially open up a lot of doors to a lot of different questions in a lot of different places in regarding how that would affect this case in particular. I don't believe that the Court of Appeals, but again, since I do not believe that the Court of Appeals erred in their decision, I do not believe that it would be appropriate for the Supreme Court to take that issue up at this time. But also I recognize that the due process is a de novo issue that can come before the Supreme Court. Your Honors, the reason why I think I'm just going to go directly to question 2, which was how his constitutional right, including his right to due process, was violated in district court. And I would quote BJM again, which was that the due process is flexible and calls for procedural protections as the particular situation demands. And I think that in this particular situation where we were 30 months into the COVID-19 pandemic and approximately 10 months prior to its end, we were, and with each individual correctional facility having their own lockdown procedures, that essentially that the best that was provided, that the state did provide the best that they possibly could to HS in order to get him to where he needed to be, or to give him the most opportunity. And the state also did believe that he was able to hear the trial, see the witnesses, confer with his attorney, and had actually spoken with his attorney earlier that day. And the fact that father did not request bifurcation or continuance at either the pretrial or the close of state's evidence, never did he once object to a proceeding, inform the court specifically he wished to testify, or at any point make an ineffective assistance of counsel claim. And based upon that, the state would ask that the court affirm the lower court's findings.
Could the entire hearing have been done by Zoom?
Yes, Your Honor. It was.
Well, no, it wasn't. It was in person except for father, wasn't it?
Yes, Your Honor. I meant
So-
that the entire hearing was broadcasted over, or was.
Could the entire hearing, I apologize for not being clear. Could the entire hearing have been done by Zoom with all the abilities that the Zoom platform allows, including private rooms, and the ability for everyone to see, hear, and talk, see everything that was going on. Was it possible to do this entire hearing by Zoom?
I believe so. It might have been, Your Honor.
May it please the court. Briefly, I'd like to provide that record on appeal citation to the discussion at the end of the transcript regarding the audio quality. That's volume 3 of the record, page 117. It was in the course of the judge's discussion regarding setting this matter for her decision. And the quote there from the judge was, "I think he's probably been able to hear me okay today. I don't know how well he's been able to hear everyone else, but he'll be able to hear my opinion being rendered on May 25th. And that's record 3 at page 117, since we had that discussion regarding audio quality. So I don't have anything to add unless there are any further. Thank you, Your Honors.
Thank you to both counsel. The court will take this matter under advisement. The court will now be in recess until 5 minutes till the hour.